Assalamualaikum and hi everyone. Today our group will be present about topic 7, Understanding UCP 600. Okay, my name is Nazatul Nasuha binti Jamari, metric number 264292, and I will explain about introductions, history and comparison between UCP 500 and UCP 600. What is UCP 600? UCP 600 means the Uniform Custom and Practice for Documentary Credits. It is a set of rules agreed by the International Chamber of Commerce which apply to finance institutions which issue letter of credits, which is financial instruments helping companies finance trade. So many banks and lenders are subject to these regulations which aims to standardize the international trade, reduce the risk of trading goods and services, and govern trade. The 39 articles of UCP 600 are comprehensive and a practical working aid to bankers, importers, exporters, transfer executives, lawyers, and everyone involved in letter of credit transactions worldwide. Next, history of UCP. The first version rules published by International Chamber of Commerce ICC in 1933 known as UCP 82. It has been revised 6 times to keep pace with market needs and practices. In 1951, UCP 151, 1962, UCP 222, 1974, UCP 290, and 1983 UCP 400, 1993 UCP 500, and the latest version in 2007 known UCP 600, first published in December 2006 and implemented on 1st July 2007. So, what's the reason for the UCP 600? The UCP 600 replaced the UCP 500 on the 1st July 2007. It was brought about standardized a set of rules aiming to benefit all parties during a trade finance transactions. UCP 600 was created by industry experts and mandated by the Banking Commission rather than through legislation. The first UCP was created in 1933 and has been revised by the ICC up to the point of the UCP 600. Next, comparison on between UCP 500 and UCP 600. In the first place, the UCP 500 comprises 49 articles, whereas the UCP 600 was reduced to 39 articles, which is simpler, clearer, more concise, and more organized. One of the remarkable changes made by UCP 600 is that it removes the relevant sections with regard to the revocable credit, which is it removed Article 6 and Article 8 in UCP 500. The UCP 500 established that the revocable letters of credit could be amended or cancelled at any time before making payment. So, on the other hand, in UCP 600, the irrevocable letters of credit is set as the default credit. Given the interpretation stated in Article 3 of UCP 600, a credit is irrevocable even if there is no indication to that effect. Finally, the UPC 600 provides more convenience for the transactions and banking services than the formal UCP 500. In respect of the dealing with the discrepant documents, 4 methods are clearly stipulated in Article 16 C3. This stipulation is convenient for both the beneficiary and applicant.
Assalamualaikum warahmatullahi wabarakatuh and good day. I am Siti Sarah binti Shuhaimi, metric number 264409. I'll present Article 1 to 10. First of all, Article 1 stated that UCP will be applied to any documentary credit when the terms of the credit specifically states that it is subject to these rules. They are obligatory on all parties unless the credit expressly modifies or excludes them. Meanwhile, Article 2 defines several terms that are used in this UCP. One of them is negotiation. Negotiation means the purchase by the nominated bank of draft and/or documents under a complying presentation by advancing to advance funds to the beneficiary on or before the banking day on which reimbursement is due to the nominated bank. Nominated bank is bank which the credit is available or any bank in the case of a credit available with any bank. Owner may define to three definitions and one of them is to pay at sight if the credit is available by sight payment. Next, Article 3 describe interpretation. In this article, it says that a credit is irrevocable even if there is no indication to that effect. The words to, until, till, from and between when used to determine a period of shipment include the date or dates mentioned, and the words before and after exclude the date mentioned. The words from and after when used to determine a maturity date exclude the date mentioned. About sub-article 4A, it is stated that a credit by its nature is a separate transaction from the sale or other contract on which it may be based, while sub-article 4B, an issuing bank should be discouraged any attempt by the applicant to include as an integral part of the credit copies of the underlying contract, pro forma invoice and the like. Followed by Article 5, which states banks deal with document and not with goods, services or performance to which the documents may relate, and while sub-article 6A express that a credit available with a nominated bank is also available with the issuing bank. Sub-article 6T2, which express a place for presentation other than that of the issuing bank, is in addition to the place of the issuing bank, and as sub-article 6E express that except as provided in sub-article 29A, a presentation by or on behalf of the beneficiary must be made on or before the expiry date. Next, sub-article 7A1 express that side payment, deferred payment or acceptance with the issuing bank, and sub-article 7A2 which express side payment with a nominated bank and that nominated bank does not pay, as well as sub-article 7B express that an issuing bank is irrevocably bound to honor as of the time it issues the credit. In sub-article 8B states that a confirming bank is irrevocably bound to honor or negotiate as of the time it adds its confirmation to the credit, and sub-article 8D states that if a bank is authorized or requested by the issuing bank to confirm a credit but is not prepared to do so, it must inform the issuing bank without delay and may advise the credit without confirmation. Followed by Article 9, which sub-article 9D states that a bank utilizing the service of an advising bank or second advising bank to advise a credit must use the same bank to advise any amendment thereto, and sub-article 9 states that if a bank is requested to advise a credit or amendment but elects not to do so, it must so inform without delay the bank from which the credit, amendment or advice has been received. Last but not least, Article 10. Sub-article 10D states that a bank that advises an amendment should inform the bank from which it received the amendment of any notification of acceptance or rejection, while sub-article 10E states that partial acceptance of an amendment is will not allowed and will be deemed to be notification of rejection of the amendment.
Assalamualaikum warahmatullahi wabarakatuh. My name is Puteri binti Abdul Malik. My metric number is 264305. Today I will present about Article 11 until Article 20. Okay, we will start with Article 11. Article 11 talk about teletransmitted and pre-advised credit and amendment. And authentic teletransmissions of a credit or amendment will be deemed to be the operative credit or amendment, and any subsequent mail confirmation shall be disregarded. A preliminary advice of the issuance of the credit or amendment shall only be sent if the issuing bank is prepared to issue the operative credit or amendment. An issuing bank that sent a pre-advice is irrevocably committed to issue the operative credit or amendment without delay in terms not inconsistent with the pre-advice. Article 12 talk about nomination. Nomination does not obligate nominated bank to honor. By nominating a bank to accept a draft or incur a deferred payment undertaking, an issuing bank authorizes that nominated bank to prepare or purchase a draft accepted or a deferred payment undertaking incurred by the nominated bank. Article 13 state about bank-to-bank reimbursement arrangement. If a credit state that the reimbursement is to be obtained by a nominated bank claiming on another party, the credit must state if the reimbursement is subject to the ICC rule for bank-to-bank reimbursement in effect on the date of issuance of the credit. If a credit does not state that the reimbursement is subject to ICC rule for bank-to-bank reimbursement, the other condition will be applied. An issuing bank is not relieved of any of its obligation to provide reimbursement if reimbursement is not made by a reimbursing bank on a first demand. Article 14 talk about standard for examination of document. Must examine document on their face to determine compliance. Other than the commercial invoice, description of goods, service or performance may be stated in the general term. Disregard document not required by LC and may be written disregard non-documentary conditions. Document may be dated prior to issuance date of LC but not later than date of presentation. In Article 14, they also talk about unspecific issuer or content, which is other than invoice, transport document or insurance document. Bank will accept the document if one, its content appear to fulfill the function and it's comply with 14D. Also, in Article 14, they also discuss about the address of beneficiary and applicant and also shipper consider transport document issuer. Article 15 talk about complying presentation. When an issuing bank determines that a presentation is complying, it must honor. When a confirming bank determines that a presentation is complying, it must honor or negotiate and forward the document to the issuing bank. When a nominated bank determines that a presentation is complying and honor or negotiate, it must forward the document to the confirming bank or issuing bank. Article 16 talk about discrepant document waiver and notice. Nominated, confirming and issuing bank may refuse to honor or negotiate discrepant document. Issuing bank in its sole judgment approach applicant for waiver. Notice of refusal may be given no later than close of the 5th banking day following day of presentations. After providing notice of refusal, the bank may return document to presenter at any time. Single notice of refusal must state the bank is refusing to honor or negotiate. Each discrepancy in respect of the refusal and one of the following conditions must have stated in the refusal notice, which is the bank is holding document pending presenter further instruction. The issuing bank is holding document until it receive waiver from applicant and agree to accept it or receive further instruction from presenter prior to agreeing to accept the waiver. The bank is returning the document. The bank is acting in accordance with instruction previously received from the presenter. In Article 17, it talks about original document and copies. At least one original must be presented. In original document, appearance of original signature, mark, stamp or label of issuer of the document. Also, an original document have a written type perforated or stamped by the document issuer hand or an original stationery or stated that it is original. LC require copies of document, either original or copies is acceptable. Document in duplicate, in two fold or in two copies, presentation of at least one original and remaining number in copies is also. Article 18 talk about commercial invoice. Invoice amount in excess of LC may be accepted by the nominated bank but must not be honored or negotiated in excess of LC amount. Issued by beneficiary made out in the name of applicant and need not to be signed. Description of goods, service or performance must be correspondent with LC description, must be in the same currently. Under Article 19, it talks about transformation document covering at least two different modes of transport. Must appear to indicate name of carrier, signed by carrier master or name agent. If signed by agent, need to specify for whom carrier or master it is signed. Under Article 20, it's talk about bill of lading. A bill of lading, however, name must appear to indicate the name of the carrier, indicate that the good has been shipped on board a named vessel at the port of loading, indicate shipment from the port of loading to the port of discharge stated in the credit, be the sole original bill of lading, or if it issue more than one original, the full set as indicate on the bill of lading, contain term and conditions, contain no indication that it is subject to the counterparty.
Assalamualaikum and hi everyone, my name is Hafiza Syuhada binti Aziz and my metric number is 264802. I will continue for Article 21, which is non-negotiable sea whale bill. The purpose of the article is the transshipment means unloading from one vessel and reloading to another. The goods will or may be transshipped provided that the entire carriage is covered by one and the same non-negotiable sea whale bill. That transshipment will or may take place is acceptable, even if the credit prohibits a transshipment. Clauses in this article state that the carrier reserves the right to transship will be discarded. For the Article 22, Charter Party Bill of Lading, the date of issuance of the Charter Party Bill of Lading will be deemed to be the date of shipment unless the board notation indicating the date of shipment. The shipment from the port of loading to the port of discharge state in the credit. Be the sole original Charter Party Bill of Lading, or if issued in more than one original, be the full set as indicated of the Charter Party Bill of Lading. A bank will not examine Charter Party contract even if they are required to be represented by the terms of credit. Article 23 is about air transport document. The information appearing on the air transport document relative to the flight number and date will not be considered in determining the date of shipment. The purpose of this article, transshipment means unloading from one aircraft and reloading to another aircraft during the carriage and state in the credit. Article 24 is about road, rail and inland waterway transport document. This is indicate the name of the carrier, be signed by the carrier or a named agent for on behalf of the carrier. The receipt of the goods by signature, stamp or notation by the carrier or a named agent. If a rail transport document does not identify the carrier, any signature or stamp of the railway company will be accepted. The place of shipment and the place of the destination state in the credit. Article 25 is about courier receipt, post receipt or certificate of posting. The name of the courier service should be stamped or signed by the named courier service at the goods are to be shipped. A requirement that courier charges are to be paid or prepaid may be certified by a transport document. The evidencing receipt of goods for transport must appear to be stamped or signed and the date at the place from which the credit state the goods are to be shipped. Article 26 about on deck, which means shipper load and count set by shipper to contain and charge additional to freight. A transport document must not indicate that the goods are or will be loaded on deck. A clause on a transport document stating that the goods may be loaded on deck is acceptable. A transport document may bear a reference by stamp or otherwise to charge additional to the freight. For Article 27, which is a clean transport document, a bank will only accept a clean transport document. A clean transport document is one bearing no clause or notation expressly declaring a defective condition of the goods or their packaging. The word clean need not appear on a transport document, even if a credit has a requirement for that transport document to be clean on board. Article 28 about insurance document and coverage. An insurance document must appear to be issued and signed by an insurance company. When the insurance document indicates that it has been issued in more than one original, all originals must be presented. Cover notes will not be accepted. An insurance document may contain a reference to any exclusion clause. An insurance document may indicate that the cover is subject to franchise or access. Article 29 tell about if the expiry date of a credit or the last date for presentation falls on the day when the bank is closed for a reason other than those referred in Article 36, the date will be extended to the first following banking day. In the first following banking day, a nominated bank must provide the issuing bank and confirming bank with a statement on its covering schedule that the presentation was made within the time limits extended in accordance with sub-article 29. The latest date of shipment will not be extended as a result of sub-article 29. Article 30 is about tolerance in credit amount, quantity and unit prices. The words about or approximately used in connection with the amount of the credit or the quantity or the unit price stated in the credit. A tolerance must only 5% for the quantity of the goods is allowed. When partial shipment are not allowed, a tolerance not exceed 5% less than the amount of the credit is allowed, provided that the quantity of the goods if stated in the credits.
My name is Che Daud. My metric number is 264352. Okay, I will continue to present about Article 31, which is partial drawings or shipments. Partial drawings or shipments are allowed. It consists of two, which is partial shipments, a presentation consisting of one or more sets of transport documents evidencing shipment on more than one means of conveyance within the same mode of transport. For example, a shipment by truck. The second one is not partial shipment. A presentation consisting of more than one set of transport documents evidencing shipment commencing on the same means of conveyance and for the same journey provided they indicate the same destination even if they indicate different dates of shipments or different ports of loading, place of taking in charge or dispatch. For example, vessel or aircraft. Next, for Article 32, which is installment drawings or shipments. If a drawing or shipment by installments within given period is stipulated in the credit and any installments is not drawn or shipped within the period allowed for that installment, the credit ceases to be available for that and any subsequent installment. Article 53, which is hours of presentations. A bank has no obligation to accept an presentation outside of its banking hours. For Article 34, disclaimer on effectiveness of documents. A bank assumes no liability or responsibility for the form, substantiation, accuracy, genuineness, falsification, or legal effect of any document or for the general or conditions stipulated in a document or superimposed theory. Nor does it assume any liability or responsibility for the descriptions, quantity, weight, quality, condition, packing, delivery, value of existence of the goods, service, or other performance represented by any document or for the good faith or acts or omissions, solvency, performance, or standing of the consignor, the carrier, the forwarder, the consignee, or the insurer of the goods or any other person. Next, for Article 35, disclaimer on transmissions and translation. A bank assumes no liability or responsibility for the consequences arising out of delay, loss in transit, mutilations, or other errors arising in the transmissions of any message or delivery of letters or documents when such message, letters, or documents are transmitted or sent according to the requirements stated in the credit or when the bank may have taken the initiative in the choice of the delivery service in the absence of such instructions in the credit. A bank assumes no liability or responsibility for errors in translations or interpretations of technical terms and may transmit credit terms without translating terms. If a nominated bank determines that a presentation is complying and forwards the documents to the issuing bank or confirming bank, whether or not the nominated bank has honored or negotiate, an issuing bank or confirming bank must honor or negotiate or reimburse that nominated bank even when the documents have been lost in transit between the nominated bank and the issuing bank or confirming bank, or between the confirming bank and the issuing bank. Furthermore, for Article 36, which is force majeure, a bank assumes no liability or responsibility for the consequence arising out of the interruption of its business by acts of God, laws, civil, commotions, insurrections, wars, acts of terrorism, or by any strikes or lockouts or any other causes beyond its control. A bank will not, upon resumption of its business, honor or negotiate under a credit that expired during such interruption of its business. In other words, limits the bank liability when a force majeure event interrupts its business. Next, for Article 37, disclaimer for acts of an instructed party. A bank utilizing the services of another bank for the purpose of giving effect to the instructions of the applicant does so for the account and at the risk of applicant. An issuing bank or advising bank assumes no liability or responsibility should the instructions it transmits to another bank not be carried out, even if it has taken the initiative in the choice of that other bank. A bank instructing another bank to perform service is liable for any commissions, fees, costs, or expenses incurred by that bank in connection with its instructions. If a credit states that charges out for the account of the beneficiary and charge cannot be collected or deducted from proceeds, the issuing bank remains liable for payment of charge. A credit of amendment should not stipulate that the advising to a beneficiary is conditional upon the receipt the advising bank or second advising bank of its charge. The applicant shall be bound by and liable to identify a bank against all obligations and responsibilities imposed by foreign laws and usage. For Article 38, which is transferable credits, a bank is under no obligation to transfer a credit except to the extent and in the manner expressly considered to by that bank. For the purpose in this article, the first one is transferable credits, which is may be made available in whole or in part to another beneficiary, which is second beneficiary at the request of the beneficiary, which is first beneficiary. The second one is transferring bank, means a nominated bank that transfers the credit or in a credit available with any bank, a bank that is specifically authorized by the issuing bank to transfer and that transfers the credit. An issuing bank may be a transferring bank. And the last one is transferred credit, means a credit that has been made available by the transferring bank to a second beneficiary. In Article 38 also, bank not obligated to the effect transfer. All charges relating to the transfers are for the account of first beneficiary. If LC allows partial drawings or shipments, it can be transferred in part to more than one second beneficiary. Transferred LC cannot be transferred to any subsequent beneficiary. Must determine the handling of subsequent amendments. Rejection of an amendment by one or more second beneficiary does not invalidate the acceptance by any other second beneficiary. Allowable changes, which is credit amount, unit price, expiry date, period for presentations, latest shipment date, and percentage of insurance coverage. First beneficiary's name may be substituted for that of the applicant. Honor or negotiation of transferred LC may be in the second beneficiary's country. The last one is Article 39, which is assignment of proceeds. The fact that a credit is not stated to be transferable shall not affect the right of the beneficiary to assign any proceeds to which it may be or may become entitled under the credit in accordance with the provisions of applicable law. This article relates only to the assignment of proceeds and not to the assignment of the right to perform under the credit.